Residential entry in Indiana. At its basic form, residential entry is going into the dwelling, so a house, an apartment, of someone else's that's not yours, and you don't have permission to do so. The Indiana statute reads specifically that a person who knowingly or intentionally breaks and enters the dwelling of another person commits residential entry, a level 6 felony. In Indiana, a level 6 felony can carry a sentence up to 2.5 years in prison and a fine of up to $10,000. Now, residential entry is very similar to other things like robbery or burglary. We're actually in the same subsection in the Indiana Criminal Code. But the big difference here is, did you go into someone's dwelling with an intent to commit another felony? That is what differentiates residential entry from something like burglary or robbery. Did you break into that house wanting to do more crime? Now here, a lot of times what we see in the cases that we have is honest mistakes. Someone's going out, they're celebrating, having a little bit too much fun, and they mistakenly go to the wrong house. They're stumbling up the steps, they're trying to jiggle that door handle, the key's not working, they don't know. Somehow they get the door open, maybe they climb through a window, and then real homeowners come downstairs and are shocked and surprised because there's a random person in their house. Now, obviously, that's what most people do. If you wake up in the middle of the night and there's a random person in there, you're going to be upset, and that's fine. But a lot of times, these people aren't trying to go and break into someone's house. They just mistakenly go to the wrong house because they're having too much fun. Now, intoxication isn't a defense, but there are ways that we can work with the prosecutor to kind of explain the reasons why you went into that house that night. Now, there are other instances as well where you can get residential entry where it's not a mistake. So a lot of times we also see someone going over to an ex-boyfriend or an ex-girlfriend's house. Now, they may have at one time had access to that house. They even might have a key. But at some point, that privilege was taken away from them. The second that they cross the plane of that door or the plane of the window and go inside that dwelling, whether that's a house or an apartment, that is residential entry. Simply standing outside of a dwelling, banging on the door, knocking, that's not going to be residential entry. The second it becomes residential entry is when that door opens and you cross through that plane from the outside world into the inside world. It's at that point that it becomes that level 6 felony, residential entry in Indiana. Now, one defense that one might have to residential entry is that first part of the statute, knowingly or intentionally. That is the element that the state has to prove beyond a reasonable doubt to find you guilty of residential entry. And what that means is they have to prove that you either knowingly went to the wrong house or intentionally knew that the house you were going into wasn't your own. Now, if you're intoxicated, you might say, I had no clue I was going to the wrong house. I honestly believed that it was the correct house. Now, in Indiana, voluntary intoxication is not a defense, but it still gives us a little bit of wiggle room to talk to the prosecutor, try to negotiate some sort of outcome that's not going to leave you stuck with a felony. A felony conviction can have major implications on your life. It can affect parenting time. It can affect your right to vote. It can affect your right to own and possess firearms. But because this is a level 6 felony, there's ways that we can work around that to kind of reduce the impact on your life. Obviously, the biggest way is to beat the case, get it dismissed completely. But if that's not always in the cards, because this is a level 6 felony, you might be eligible for alternate misdemeanor sentencing. And what that means is that that felony at some point can be dropped to a misdemeanor. Now, alternate misdemeanor sentencing can either be at the front or the back of your sentence. And what that means is if it's alternate misdemeanor sentencing on the back end, that means that you're going to be a convicted felon for a period of time, but as long as you complete the terms that the court asks you to do, and you don't have any violations while you're on probation, you don't pick up any new crimes, then at the end of that sentence, you can ask the judge to convert that felony back down to an A misdemeanor, restoring all the rights that you lost when you were a convicted felon. Now, in some instances, you can have alternate misdemeanor sentencing on the front end. And what that means is you're never going to be a convicted felon. At the time that you plead guilty, the judge essentially converts that felony automatically to a misdemeanor, so there's never a point where you're a convicted felon. Now, the only way you qualify for alternate misdemeanor sentencing is if you do not have a lot of felony convictions and you haven't had alternate misdemeanor sentencing in the past 2 years. If you've had alternate misdemeanor sentencing in the 2 years prior, then unfortunately you are not eligible for alternate misdemeanor sentencing on this particular case. Now, if you're facing a residential entry charge, don't worry. The biggest tips that I have for you are 3. 1, do not talk to the police. The police might contact you. They might be very friendly, wanting to spark up a conversation. They are not there to be your friends. They're there to gather evidence against you. Do not talk to the police. 2, it's best that you don't talk to the person whose home was there. The state's going to call that the alleged victim. Typically, there's going to be a no contact order preventing that anyways, but before that no contact order is put in place, it is in your best interest to put that person out of your life. Now, you might be saying, Zach, I have my personal belongings in that residence. I need to go back and get my personal belongings. At the time being, it's in your best interest to not do any of that until the case at least gets in front of a judge and you've hired an attorney. And that's the biggest thing. Number 3, if you're facing any sort of criminal charge in Indiana, you should get a criminal defense attorney. And it's better to get one sooner than later. The criminal attorney is going to be able to navigate your process through the legal system. Sometimes they can make it to where you don't have to go to court. They can file numerous motions. And most of all, they're going to be the ones to negotiate with the prosecutor to try to get the best outcome for your particular situation. If you're facing criminal charges, please give us at the Marc Lopez Law Firm a phone call, 317-632-3642. And always remember, plead the fifth.